Hi everyone, Happy New Year. I thought I'd come on here on New Year's Day and just talk about some things that have been on my mind. For the past, I don't know, I guess probably ever since I read the forensic mapping report, I've really just in the back of my brain have been thinking about how justice hinges upon the prosecutor and the investigators being ethical. And if they are not trying a case, if they're not investigating a crime for the right reasons to find the true suspect, and if they're not prosecuting the person that investigators say committed the crime for the right reasons, then justice is just screwed from the beginning, right? And this is for any case. It's not just Steven and Brendan's case. It's any case. Let's take a look. Wrongful conviction exonerations in 2021. How many people were freed in 2021? Let's see. Newly discovered exonerations. And I know there have been some. All right, let's go to, this is from the Wrongful Conviction Day 2021. And it says October 2nd marks the 8th annual International Wrongful Conviction Day, a day dedicated to raising awareness surrounding wrongful convictions and discussing both causes and potential remedies. As prisons still combat COVID this year, incarcerated people across the country have experienced an isolation more heavily than any of us. And we know that's true. Just for like those of us who are in any kind of social justice, criminal justice reform community, where some of the advocates are, they do their part by corresponding with inmates. They've had, many inmates didn't have visits for over a year. And, they were all on 24-hour lockdown. So they were basically being punished for something out of their control. And prison and jails are already so isolating, and you're cut off from everyone anyway. I couldn't imagine not getting the expected pick-me-up visit from a loved one. One of the books, let's see, these are just discussing some of the great TV movies. Making a Murderer. These are documentaries. Many of these are on Netflix. Making a Murderer's on the list. I like that. The Innocence Files is really good. The Innocent Man's really good. And some podcasts. Let's see. The exonerees. Let's see what we have here. And so as of January 1st, 2022, 1,824 years, 5 months, 26 days, and 13 hours. That's crazy. Let's look. Let's see who Adam Gray is. Adam Gray says, in the early morning hours of March 25th, 1993, a fire broke out on the rear stairs of a 2-flat apartment building in Chicago, Illinois. Second-floor residents Peter McGinnis and his sister, Margaret Mesa, both perished in the blaze. Oh, wow, he was only 14. It says residents on the first floor escaped, including 14-year-old Casey Paris, her parents, and her brother. Paris told police that she had recently been threatened by 14-year-old Adam Gray, who was angry that Paris was dating Gray's best friend. Carrie Kelly told police she saw a teenager running away from the back of the building carrying a white bag. She later identified Gray in a photographic lineup, although she knew Gray and had not mentioned him by name, in her first interview with police. Let's see. After 7 hours of interrogation, he confessed. He said that he bought gasoline in a milk jug, dumped it on the rear stairs, and ignited it with the lighter. Not long after, he recanted, saying he finally yielded to police pressure and admitted he set the fire. After they got the confession, they went and found a milk jug at the scene, and they sent that for testing. Gray was charged as an adult with first-degree murder and aggravated arson. He went to trial in April of '96 in Cook County. They introduced the confession and testimony of a store clerk who said that she sold gasoline to Gray before the fire, although she said she put the gas into a red gas can, not a milk jug. Casey Paris, the little girl who escaped, testified that Gray had threatened her, and Carrie Kelly testified that she saw a teenager carrying a white bag run from the back of the building just before the fire erupted. Crime scene analysts testified that tests on the milk jug revealed the presence of a high boiling petroleum distillate. They also testified that tests performed on debris revealed the presence of a middle through high petroleum distillate. There was no testimony explaining what that even means. 2 arson investigators testified they found alligator charring and deep burn patterns after the blaze was extinguished. They concluded that those were signs that the fire had burned very hot and fast and was started with an accelerant. In April of '96, the jury convicted him on 2 counts of first-degree murder and aggravated arson. He got life without parole. In the ensuing years, arson investigators and scientists began to show that evidence arson investigators had traditionally relied on was scientifically invalid, including the determination that alligator charring was evidence that an accelerant had been used. In 2006, so that's 10 years later, Thomas, who had identified Gray as the person who bought gas shortly before the fire, recanted her ID. She said she was pressured by police, not surprising, to identify Gray, and at first identified someone else from a photographic array. After police told her she was wrong, however, she eventually picked Gray. They failed to disclose to Gray's trial lawyer that Thomas had initially picked someone else. In 2007, Casey Paris also recanted her testimony that Gray had threatened her. Paris said Gray never directly threatened her and that her testimony was the result of being coached by police and prosecutors to portray herself as the good girl victimized by Adam Gray. Paris said that Gray did not intimidate or frighten her. Wow. Hi everyone, Happy New Year. I thought I'd come on here on New Year's Day and just talk about some things that have been on my mind. For the past, I don't know, I guess probably ever since I read the forensic mapping report, I've really just in the back of my brain have been thinking about how justice hinges upon the prosecutor and the investigators being ethical. And if they are not trying to, if they're not trying a case, if they're not investigating a crime for the right reasons to find the true suspect, and if they're not prosecuting the person that investigators say committed the crime for the right reasons, then justice is just screwed from the beginning, right? And this is for any case. It's not just Steven and Brendan's case. It's any case. Let's take a look. Wrongful conviction exonerations in 2021. How many people were freed in 2021? Let's see. Newly discovered exonerations. And I know there have been some. All right, let's go to, this is from the Wrongful Conviction Day 2021. And it says October 2nd marks the 8th annual International Wrongful Conviction Day, a day dedicated to raising awareness surrounding wrongful convictions and discussing both causes and potential remedies. As prisons still combat COVID this year, incarcerated people across the country have experienced an isolation more heavily than any of us. And we know that's true. Just for like those of us who are in any kind of social justice, criminal justice reform community, where some of the advocates are, they do their part by corresponding with inmates. They've had, many inmates didn't have visits for over a year. And, they were all on 24-hour lockdown. So they were basically being punished for something out of their control. And prison and jails are already so isolating, and you're cut off from everyone anyway. I couldn't imagine not getting the expected pick-me-up visit from a loved one. One of the books, let's see, these are just discussing some of the great TV movies. Making a Murderer. These are documentaries. Many of these are on Netflix. Making a Murderer is on the list. I like that. The Innocence Files is really good. The Innocent Man's really good. And some podcasts. Let's see. The Exonerees. Let's see what we have here. And as of January 1st, 2022, 1,824 years, 5 months, 26 days, and 13 hours. That's crazy. Let's look. Let's see who Adam Gray is. Adam Gray says, in the early morning hours of March 25th, 1993, a fire broke out on the rear stairs of a 2-flat apartment building in Chicago, Illinois. Second floor residents Peter McGinnis and his sister Margaret Mesa both perished in the blaze. Oh, wow, he was only 14. It says residents on the first floor escaped, including 14-year-old Casey Paris, her parents, and her brother. Paris told police that she had recently been threatened by 14-year-old Adam Gray, who was angry that Paris was dating Gray's best friend. Carrie Kelly told police she saw a teenager running away from the back of the building carrying a white bag. She later identified Gray in a photographic lineup, although she knew Gray and had not mentioned him by name. Oh, wow, in her first interview with police. Let's see. After 7 hours of interrogation, he confessed. He said that he bought gasoline in a milk jug, dumped it on the rear stairs, and ignited it with the lighter. Not long after, he recanted, saying he finally yielded to police pressure and admitted he set the fire. After they got the confession, they went and found a milk jug at the scene, and they sent that for testing. Gray was charged as an adult with first-degree murder and aggravated arson. He went to trial in April of '96 in Cook County. They introduced the confession and testimony of a store clerk who said that she sold gasoline to Gray before the fire, although she said she put the gas into a red gas can, not a milk jug. Casey Paris, the little girl who escaped, testified that Gray had threatened her, and Carrie Kelly testified that she saw a teenager carrying a white bag run from the back of the building just before the fire erupted. Crime scene analysts testified that tests on the milk jug revealed the presence of a high boiling petroleum distillate. They also testified that tests performed on debris revealed the presence of a middle through high petroleum distillate. There was no testimony explaining what that even means. 2 arson investigators, testified they found alligator charring and deep burn patterns after the blaze was extinguished. They concluded that those were signs that the fire had burned very hot and fast and was started with an accelerant. In April of '96, the jury convicted him on 2 counts of first-degree murder and aggravated arson. He got life without parole. In the ensuing years, arson investigators and scientists began to show that evidence arson investigators had traditionally relied on was scientifically invalid, including the determination that alligator charring was evidence that an accelerant had been used. In 2006, so that's 10 years later, Thomas, who had identified Gray as the person who bought gas shortly before the fire, recanted her ID. She said she was pressured by police, not surprising, to identify Gray, and at first identified someone else from a photographic array. After police told her she was wrong, however, she eventually picked Gray. They failed to disclose to Gray's trial lawyer that Thomas had initially picked someone else. In 2007, Casey Paris also recanted her testimony that Gray had threatened her. Paris said Gray never directly threatened her, and that her testimony was the result of being coached by police and prosecutors to portray herself as the good girl victimized by Adam Gray. Paris said that Gray did not intimidate or frighten her. Wow. So it says, in 2007, Paris also recanted her testimony that Gray had threatened her. He never directly threatened her. Her testimony was the result of being coached. Defense attorneys for Gray consulted experts who re-examined the case. Actually, let me go back up here and read this. Paris said Gray never directly threatened her and that her testimony was the result of being coached by police and prosecutors to portray herself as the good girl victimized by Adam Gray. Paris said that Gray did not intimidate or frighten her. Now, isn't that funny? Because if you think about it, for those of you who know anything about the Teresa Halbach investigation, Kratz, Gahn, and Fallon really want people, they did during the trial, during the investigation, during the trial, and even in the post-conviction world, they want people to think that Teresa Halbach was a demure Catholic schoolgirl who, was a virgin, and Steven Avery was this big bad evil man who, who scared the bejesus out of her. But the reality is that was not who Teresa was, and that's not how she felt about Steven Avery, and that wasn't who Steven Avery was either. And what you see in these cases of wrongful convictions, that prosecutors and investigators have to trick people into thinking that the victim and the defendant, or the person who's being tried for the crime, are different than who they really are. And if you're having to trick people to believe something that isn't true, why? If the truth works, if the truth is that they did the crime, you shouldn't have to fool anyone into thinking that they could have done it. You should be able to present the evidence, and the evidence will do that for you, right? So, I'm seeing that in all these wrongful convictions. So anyway, back to the Adam Gray case. Attorneys for Gray consulted experts who re-examined the case. Experts concluded testimony about evidence of arson in the case had been debunked and did not prove arson. And arson is another crime where they use a lot of subjective science so these experts get on the stand. They are convinced by prosecutors that they're helping to put the right person in prison for the crime. So they're making statements that the science really doesn't support. So defense experts also reported that petroleum distillates are not gasoline, are nowhere near as flammable as gasoline, and actually are terrible accelerants. The distillates found are commonly found in fire debris because they are present in innumerable household products such as wood treatments and solvents, and therefore did not prove that the fire was started with an accelerant. Moreover, the defense experts said, the substance found in the jug differed from the substances found in the fire debris. The bench notes of the crime lab analysts, which were never disclosed to the defense, that's prosecutorial misconduct, showed that no gasoline had been found in the debris or the milk jug. Gray's lawyers sought a new trial based on the new evidence. Now, this is in 06 and 07. And the failure of Gray's trial defense attorneys to consult an expert regarding the arson evidence. In 2016, so this poor guy has been in prison for 20 years. He was a kid. He was 14 when he was arrested. In 2016, the Cook County State's Attorney's Conviction Integrity Unit began its own reinvestigation of the case. After consulting other arson experts, the prosecution agreed that Gray should be granted a new trial, although the prosecution said they would seek to retry Gray because they believed he was responsible for the fire. Even though the prosecution agreed that Gray was entitled to a new trial, in 2016, the Cook County Circuit Court Judge Angela Patrone denied Gray's motion for a new trial. Wow. In 2017, the prosecution and lawyers for Gray presented a joint motion to vacate the conviction and dismiss the case. Scientific advances since the time of trial have proven that the fire investigators' testimony, while based on beliefs that were widely held in 1996, was erroneous under current scientific knowledge, the motion said. Gray was released that day. Thank goodness. In 2018, he was awarded a certificate of innocence, enabling him to seek compensation from the state of Illinois. In April 2018, he filed a federal civil rights lawsuit seeking damages from the Chicago Police Department. Wow, I wonder if he's settled yet. Let's see. There's no amount of money that can make up for what was done to that kid. Adam Gray, civil rights lawsuit settlement, Illinois. Let's see. 2019. No, it looks like it's still. Yep, he's still trying to get compensation. So he filed in 2018. This is now 2022, the beginning of. So he's going on 2020. He's going on 4 years without a settlement. I think about that. I wonder. I don't see how Wisconsin wouldn't have settled with Steven, because the more they dug in their heels, the higher up they would have shown there was negligence and culpability, right? Let's look at Anthony Jakes. Oh, another Chicago case. On May 17th of 91, 16-year-old Gerard Irving was shot twice in the head during an apparent robbery attempt by a rival gang member at his residence in the 900 block of West 54th Street on the south side of Chicago. The crime was still unsolved on September 15th when 48-year-old Rafael Garcia was fatally shot during an attempted robbery about a mile away. On September 16th, police said a tip, an anonymous caller, reported that 15-year-old Anthony Jakes, who lived on 51st Street a few doors down from the shooting of Garcia, had info about the crime. Jakes later said that police came into his home without a warrant and took him to the police station, where an officer planted drugs on him in the lockup. He was then put into an interrogation room where, after Detective Michael Kill kicked and beat him, he signed a confession, another false confession. In it, he admitted that he acted as a lookout while another man, Arnold Day, 18 years old, shot Garcia during an attempted holdup. He was charged with felony murder and attempted armed robbery. Despite that statement, police did not arrest Day until February 4th of 92. Police said that he also confessed, not only to the murder of Garcia, but to the murder of Irving. The Garcia murder case was prosecuted first. Jakes and Day filed motions to suppress their confessions, claiming they falsely confessed after Kill and Boudreaux physically abused them. The detectives testified that after they took Jakes into the station, he was searched and they found a package of drugs in his pocket. They charged him with possession, and then they spoke with him. They said Jakes gave them the names of 3 girls he was with the evening before. They testified that the girls denied seeing Jakes. In addition, the detectives said a witness, Gus Robinson, who was in custody in an unrelated charge, reported that just before the shooting, Jakes approached him on the street and asked if he wanted to be a lookout for a planned robbery. When confronted with that evidence, they said Jakes admitted that he was the lookout for Day in the shooting of Garcia. In the confession, Jakes said that after the shooting, he ran home and looked out the second-story window to see Garcia's body on the ground. Both detectives denied physically harming Jakes. Jakes testified that Kill knocked him to the floor and kicked him in the chest until he finally agreed to confess. His statement was not given until about 4 a.m., 16 hours after he was first taken from his home. It was not until then that a juvenile officer whose presence was required during the interrogation of a juvenile was actually summoned to speak to Jakes. Jakes said he gave his statement only because Kill threatened to give me more of what I had just had. The defense presented photographs that were taken during Jakes' initial appearance that showed bruises on his body. This reminds me of that poor kid in Jacksonville. Another Making a Murder foul play community member, I believe it was Jazznaz, told me, I think it's called A Murder on a Sunday Morning. If anyone hasn't seen that documentary, you can watch it on YouTube. It's an HBO one. Those Jacksonville cops framed that kid, and thank God he had a good public defender, or he'd still be in prison to this day. They beat him too. It's a really, really good documentary. That public defender actually just passed away a couple of years ago. Yeah. Let's see. In rebuttal, Detective Boudreaux testified that other police officers reported that Jakes had been in a fight with neighborhood youths prior to the shooting. So he used cops. You see how they do that? I didn't beat him up. Cops told me other kids beat him up. A physician who examined Jakes the day he confessed testified for the prosecution that his examination showed an older injury to Jake's back, but no fresh injuries. Wow. The motion to suppress the confession was denied. The judge ruled that the search that allegedly turned up drugs was unlawful and that the failure to call a juvenile officer was an item to be put on the defendant's side of the ledger. However, because the defense had failed to prove his injuries were suffered while at the police station, the judge found that the confession was voluntary. Jakes and Day went to trial simultaneously, but with separate juries in September of 93. However, because the defense had failed to prove his injuries were suffered while at the police station, the judge found that the confession was voluntary. Jakes and Day went to trial simultaneously, but with separate juries in September of 93. Robinson testified that at 6 p.m. on the night of the shooting, he took his 18-month-old to play on the swings at Sherman Park. He was still there at 11:45 p.m. when he received a notification on his pager. He said he drove to Oliver's Chicken Shack on the corner of Racine Avenue and 51st Street to use a payphone. While he was standing at the phone, Robinson said Jakes approached and asked if he would stand point and watch for police while he and Little A, who's Day, and them was robbing this white guy. Robinson said he looked through the window of a submarine sandwich shop next door, saw a man at the counter, and told Jakes he wasn't with it. Robinson said he drove away, and after stopping a few blocks away to talk to friends, he heard gunshots. Robinson identified a photograph of Garcia as the man he saw at the counter. The prosecution presented Day's and Jake's confessions and testimony from Boudreaux and Kill, both of whom denied physically abusing either Day or Jakes. Can I just say, with the last name Kill, if you choose to be an officer, you should go out of your way to be the best, most law-abiding, community-oriented officer you can. Because if not, you're just giving people the opportunity to say, well, a cop named Kill, what do you expect? Of course he's dirty, right? Sorry. Anyway, the prosecution presented Day's and Jake's confessions and testimony from Boudreaux and Kill, both of whom denied physically abusing either Day or Jakes. Day presented evidence that he was elsewhere at the time of the crime. The defense presented no evidence on Jake's behalf. Probably a public defender or pretender. I guess, I hats off to all public defenders, overworked, underpaid, but 90% of them are shit. And to the 10% of you who do your job because you have a calling and you know that our criminal justice system is slanted to be disadvantaged for, the marginalized of society, people of color, low income poverty, the good kids who come from bad families, but yet get hemmed up because of shit like this. My hat's off to you. You wear a white hat in a world where it's very difficult to do the right thing and advocate for people day after day after day. For very little money. I do it for free, on YouTube and other social media sites. So I think that anyone who's in the public defender's office should be there because they know that they are desperately needed to do their work, right? The gentleman and actually there was two of them. There was a lady too. The gentleman and lady in the documentary A Murder on Sunday Morning about the juvenile in Jacksonville who the police beat up and tried to frame for murder. Those two were definitely two white hats in the criminal justice system. Day presented evidence that he was elsewhere at the time of the crime. The defense presented no evidence on Jake's behalf. On September 10th, 1993, Day was acquitted by his jury. Wow, good for him. Jakes was convicted of felony murder and attempted armed robbery. He was sentenced to 40 years in prison. Prior to Day's trials on charges of murder and attempted robbery of Irving, his defense attorneys filed a motion seeking to bar use of his confession. Day testified that when he was arrested, Officer Judd Evans kicked him in the head and threatened to blow my brains out. Wow. Day testified that he was handcuffed and taken to the police station at 51st Street and Wentworth Avenue, where he was put into an interrogation room. There, he said, he was punched, kicked, and slammed against the wall repeatedly during interrogations by Boudreaux, Foley, and Halloran. At one point, Foley threatened to throw him out of a second-floor window. Day testified that he confessed based on details fed to him by the detectives. We know that's what Brendan Dassey did in this case, in the Teresa Halbach case. Boudreaux testified and denied that Day was mistreated or was fed details of the crime. The judge denied the motion to suppress the confession. In June of 94, Day went to trial for the murder and attempted robbery of Irving, who was found shot twice in the head in the hallway of a building. During opening statements to the jury, the prosecution said that Ralph Watson would testify that Day had admitted to him that he committed the murder. However, Watson was ultimately not called to testify because he had recanted his statement implicating Day. Watson told the prosecution that he was in Cook County Jail facing armed robbery charges when Boudreaux arranged for him to be brought to the police station. Watson said Boudreaux threatened to charge him with more crimes unless he implicated Day. Watson refused to testify because he said Day had never admitted anything to him. Good guy. A defense motion for mistrial based on the prosecution's reference to Watson's statement was denied. Wow. A police evidence technician testified that 2 shell casings and an expended bullet were found near Irving's body. The primary evidence against Day was his confession. Boudreaux testified that Day initially denied committing the crime, but after being shown the statement from Watson, he admitted his involvement. Boudreaux said Day admitted he shot Irving with a Tec-9 after Irving resisted a robbery attempt. He said he was accompanied by another man named Nate. According to the confession, Day and Nate were members of the Blackstone Street Gang, and they went to a house where members of an opposing gang lived. The confession said that as they approached the house, they heard gunshots. Day fired back and killed Irving. Day's attorney tried to present evidence that about a month after the shooting, police recovered a gun from a man that was linked by ballistics testing to the shell casings recovered near Irving's body. The man had not been charged in Irving's murder, so they just let the real guy go. The judge declined to allow the evidence, even though the gun that was matched to the murder was a Smith & Wesson semi-automatic pistol. It was not a Tec-9, which Day's confession said he used to shoot Irving. Kind of like Brendan's false confession, nothing can be corroborated, right? Day testified and denied involvement in the crime. He said that Foley had choked and struck him, shoved him against a wall, and threatened to throw him out the window. The prosecution called Officer Evans and Detective Foley in rebuttal. They denied mistreating Day in any way. Of course they did. On June 23rd, 1994, my birthday, the jury convicted Day of first-degree murder and attempted armed robbery. He was sentenced to 60 years in prison. The Illinois Appellate Court upheld the convictions in 96. A post-conviction motion for a new trial was filed in 97. It was dismissed, and an appeal was unsuccessful. Jake's conviction was upheld by the Illinois Appellate Court in 95. The Supreme Court denied him leave to appeal in 96. Acting without a lawyer, Jakes filed a PCR in February of 96, claiming his trial defense lawyer had failed to investigate the case. that Detective Kill had kicked, beaten, and threatened to kill him, and that police had failed to call a juvenile officer. The Cook County Public Defender's Office was appointed to represent him on the petition in May of 96. 2 months later, in July, the prosecution filed motion to dismiss the petition. Nearly 7 years later, in January of 2003, an assistant public defender was finally assigned to handle the petition. In 2004, a supplemental petition was filed claiming that his trial defense lawyer had failed to call alibi witnesses who could have testified that Jakes was not at the shooting. The petition also cited the defense lawyer's failure to determine that it was impossible to see the street where Garcia was shot from the window of Jake's home, as his confession stated, because his home faced the alley, not the street. The petition cited this evidence as proof that the confession was false. The prosecution's motion to dismiss was granted. Wow. Jakes appealed, and in 2006, the Appellate Court of Illinois remanded the case for an evidentiary hearing to allow the defense to develop evidence supporting Jakes' claim that his confession was the product of physical abuse. However, shocker, the trial court judge denied a defense motion to require the prosecution to produce evidence of past misconduct. Holy shit. Let me read that again. However, the trial court judge denied a defense motion to require the prosecution to produce evidence of past misconduct by detectives Kill and Boudreaux. As a result, the defense ultimately filed another petition based on information uncovered in its own investigation, as well as information published by the Chicago Tribune in an article detailing false confessions obtained by Boudreaux. Now, all right, how is a judge only after the truth and justice if they're not going to allow an officer's past misconduct into play? That makes no sense. Why would they not compel the prosecution to produce the evidence? That's like almost suborning, is that how you say it? Suborning perjury, or the Brady. Let me help you not give the defense the evidence to prove that the officers who the defendant is claiming beat him, and threatened him and scared him into falsely confessing. Don't let me make you give you evidence that that's the kind of cops they are. That just makes no sense. Anyway, that's how our criminal justice system is. It's unbalanced. How is that helpful in seeking justice and the truth? It's not. It really isn't. So the amended petition cited allegations of physical abuse and coerced confessions in 13 cases. Wow. Involving Kill, and 16 cases involving Boudreaux. Now, not only are we talking about 16 people who have been wrongfully convicted, we're also talking about 16 criminals who have been allowed to remain free to go and harm others, right? So this is why wrongful convictions are so devastating to so many, because it not only denies the victim justice, not only does it steal the life of the wrongfully convicted person, not only does it damage the family members of all those people, but then you have the real perpetrator. They're allowed to remain free to continue harming others. And these officers who do this get away with it, so then they think they can continue doing it. It's a very toxic circle that and actually it's not a circle, it's a very toxic environment that only breeds more and more and more victims. There's nothing good to be gained by allowing our justice system to continue on in this vein. It doesn't, because when it goes wrong, it goes really wrong. And when you get judges and officers and DAs in a county or in a circuit where they're getting away with doing this, they're going to keep on. And they don't just do one case. They see that they get away with it, so then they do it again. And then it becomes easier, and then they do it again. And then they do it again. And meanwhile, the real perpetrators are out there steady harming other people, and no justice is getting served. People's lives are being ruined. And it's a tragic. It's epically tragic. And we've got to do something about that. So the trial court, imagine that, dismissed all the allegations involving Boudreaux because Jake said that only Kill beat him and that Boudreaux merely watched it happen. The court also refused to consider all claims against Kill before 1988 as too remote in time to the 91 confession, and eventually reduced the number of relevant allegations against Kill to just 2 prior cases. The judge denied relief, finding that 2 cases were not sufficient to show a pattern of misconduct to support Jake's claim. What the hell? What the hell? Boudreaux and Kill both worked under the command of Lieutenant John Burge, who in 2010 was convicted in federal court of perjury for denying torture allegations during questioning in federal lawsuits brought by other torture victims. He was sentenced to 4.5 years in prison. Good. I hope he suffered every day. Officers under Burge's supervision employed various methods of torturing suspects, including, my God, electric shocks, putting guns in their mouth, oh my God, staging mock executions, and tying a suspect to a radiator. Wow. And they won't do that to wealthy citizens, wealthy suspects. These are marginalized suspects. These are suspects who don't know their civil rights. They don't know they have a right to an attorney. They don't know enough to demand to be treated with, dignity. And that is just frigging disgusting to me. As part of the re-examination of the torture allegations, the Illinois Torture Inquiry and Relief Commission was established in 2009 to investigate claims of police torture. Defendants with credible claims could qualify for awards of up to $100,000 as well as other benefits. Jakes appealed the dismissal of his post-conviction petition and was now represented by lawyers at the Exoneration Project at the University of Chicago Law School. Thank goodness. In 2013, the Illinois Appellate Court again reversed the trial court and remanded the case for further hearings. Jakes was out of prison by then. He was released on parole in 2012. The appellate court ruled that Jake's lawyers were entitled to any information that the prosecution had about both detectives. The court noted that Kill had testified under oath in a different case that he had gotten confessions in about 90% of the murders he investigated, and that he had been accused of physically beating suspects in virtually all of those cases. Wow. The court also said the prosecution was required to produce evidence relating to Boudreaux. The officer's silent acceptance of the crime committed by a fellow officer can help persuade their victim that no one associated with police will help him, and he will face worse beatings if he tells a police officer, an assistant state's attorney, or a doctor working for the state about the beatings, the court said. Moreover, Boudreaux's testimony, both at trial and on the motion to suppress, puts his credibility in issue, and evidence that he committed perjury in other cases could significantly affect the credibility of his testimony here. All of that is common sense. That the Supreme Court has to tell the circuit court that tells me that there's something wrong with this judge as well. By that time, the Illinois Torture Inquiry and Relief Commission had found credible evidence that Kill had physically abused Jakes. Day also had filed a claim with the Torture Commission. Ultimately, Detective Kill took the witness stand at an evidentiary hearing before Cook County Circuit Court Judge William Hooks in January of 2016. By that time, records showed that Kill had been accused of abusing suspects in 19 different cases, including the use of electric shocks. 2017, the Torture Commission found that Day's allegations of torture during interrogation were credible. Although Boudreaux and Foley have denied the incidents Day described ever occurred, there is pattern and practice evidence suggesting that both officers may have engaged in abusive conduct during police interrogations, the commission concluded. Moreover, given that a jury acquitted Day of the murder of Rafael Garcia despite a signed confession to that crime, it is reasonable to conclude that the jury did not credit testimony by the officers contradicting Day's alleged mistreatment. The commission noted that for 2 decades, Day had consistently maintained his innocence and that he was physically beaten. Alright, they filed a PCR for Day. The petition cited nearly 50 cases, primarily murders and other violent crimes in which Boudreaux, Foley, Kill, and Halloran, and other detectives working with them were accused of beating and torturing defendants during interrogations and similarly physically abusing witnesses to falsely implicate defendants. Wow. The petition also cited a sworn statement from Crona Taylor, who lived in the building where Irving was murdered. Taylor said police, including Boudreaux, interrogated her for 16 hours after she said she saw 2 people come towards the building and then heard gunshots. Ultimately, she gave police a number of names, including Day's, who she had seen in the neighborhood. She told police that the 2 people who approached the building were a male and female. Her description of the male did not fit the description of Day. In the statement, Taylor said that Day, whom she knew, was not the male. Day's defense attorney did not interview Taylor prior to Day's trial. Greenberg noted that the gun that police said was linked by ballistics to the shootings was a Smith & Wesson, not a Tech 9, which was the gun Boudreaux said Day confessed he used to shoot Irving. All right. Oh, good. So on April 30th, 2018, Robert Milan, who had been appointed as a special prosecutor to handle the cases of Jakes and Day, asked that Jake's convictions be vacated and then dismissed the case. On December 17th, 2018, Milan asked that Day's convictions in the Irving murder case be vacated. The motion was granted. Milan then dismissed the case and Day was released. In 2019, Jakes filed a federal civil rights lawsuit against the city of Chicago seeking damages for his wrongful conviction. He obtained a certificate of innocence, and in July of 2019, he was awarded, get this, a whopping $230,000, $810 in state compensation. That's disgusting. So his lawsuit is still ongoing as well. Well, there's a few cases. I'm talking about these cases I'm trying to show that wrongful convictions have so many similarities. Even if the crimes are not similar, like how they were committed, how the officers and DAs and judges obtain the convictions and then uphold them for years are the same, right? They ignore compelling evidence. Like, what judge in their right mind doesn't say or doesn't allow the defense to use prior bad acts? If it was against the defendant, they would be used. But because they were against the officer, you don't, I mean, in an officer, it should be even more concerning, especially when, you've got a kid saying he's been beat, threatened to be thrown out of a 2-story window. So it's the system as a whole. That whole time period in Chicago must have just been rampant with false conviction or wrongful convictions, because they were getting away with it, so they just kept doing it, closing cases. Crime rates were outrageous. There was a lot of crime, which, if you're a person whose family member who has been wrongfully convicted, and you don't make great choices, it's going to cause you to go out and do things, not that it's the right thing to do, but you're going to want to rebel against the system that's stealing your loved one away. And then if you're the person who's getting away with the crime, you're going to go out and commit more crimes because you just got away with the crime you committed. It's just, it's absurd to think that closing cases this way is in any way justice. And you see the same thing over and over. False confessions, manipulating of evidence, expert testimony that in reality isn't that expert. Like like the arson case for Adam Day. Why didn't the defense bother to figure out what petroleum distillates were? Or, in the Steven Avery and Brendan Dassey case, why didn't the FBI analyst test all 6 swabs? It's just, you see that you have this, what I found by the more that I am learning about the criminal justice system and wrongful convictions and unethical DAs, judges, and officers, is that most of society has their blinders on, right? They don't get into trouble. They don't know anyone who's been in the system. And so they believe in, they have this idea of justice and truth, and, all cops are good and all DAs are great and all judges are wise and rule on the side of law, and personalities and political affiliations, and none of that gets brought into it. But that's not how it works at all. People are corruptible. Money talks. Power corrupts. Absolute power corrupts. And when you find that you can close a case, make a little bit of money, get a little bit of power, you'll do things that maybe you never thought you would do when you were in law school. And then, but once you're out of law school and you got to pay your bills and all your friends are doing bad things and getting away with it, why not? I guess. I mean, I don't know. I couldn't do it. My conscience wouldn't let me knowingly put a guy in prison. It just wouldn't happen. I would have to tell. I would have to, be one of those guys that goes against my brotherhood. I mean, maybe that's why I'm not a cop. Maybe because, I'm not going to allow people to be treated like that. I don't care if this was the worst person in the world and you just knew they did the crime. There's no reason to have to fake it. If you know he did the crime, then you work that much harder to get the evidence to show that he did it. But they knew Steven Avery didn't do the crime. They knew these 2 kids didn't do the crime. So that tells me that these guys that are calling themselves officers are in reality the criminals. And the DAs who are supposed to be, putting away the bad guys are actually helping the bad guys put away people who don't have the money or the intelligence or the education to recognize that, to speak up for themselves. They wouldn't do it to someone who had money and a good lawyer, but you know, it's okay to do because they don't know any better. That's disgusting. So, I don't know. Hopefully 2022 will see a lot of positive change in the criminal justice system. We can make some great advancements and get rid of these corruptible DAs and these bad cops and these judges who are, who are more worried about political affiliations than justice and the truth. And we've got to work on legislation for EDPA. We have to. The federal court, their hands are so tied right now when it comes to trying to intervene when the state court won't do what's right. Legislation needs to be passed so there's an avenue for state offenders to seek federal relief when the state won't do their job. So, Happy New Year. If you enjoy videos like this, hit like and subscribe. And I'll see y'all soon. Bye.